Good day to everyone, to our listeners and viewers, and especially to my colleagues at the Rizal Memorial College's School of Law. We are going to present a case that will enrich our learnings towards legal ethics. With honor and gratitude, I will introduce my esteemed colleagues that will be participating in this endeavor. Ms. Carle Mae Sanquina, Ms. Princess Mae Cabañog, Mr. Gilbert Picasales, Ms. Krizza Mae Velasco, Ms. Mylene Capricho, Mr. Nathaniel Millado, Mr. Mark Ervin Lintogonan, Mr. Arnelio Arnoco, Mr. Carl Martin de la Cruz, Ms. Miel Laquindanum, and Mr. Demostenes Libera. Today, we will be discussing the case in the matter of petition for the reinstatement of Rolando Torres as member of the Philippine Bar with AC number 5161 promulgated on August 25, 2015. So let's start. Mr. Arnoco, can you give us a preview of the case?
Here is the preview of the case. Attorney Rolando Torres was disbarred. He was administratively charged by Isidra Ting Dumali, his sister-in-law, for the following. First, presentation of false testimony. Second, participation in, consent to, and failure to advise against forgery of complainant's signature, and the gross misrepresentation in court. Having been disbarred, Rolando Torres, the respondent, seeks judicial clemency in order to be reinstated in the role of attorneys. We will find out if whether or not his petition for judicial clemency may be given merit or be granted in order for him to be reinstated in the role of attorneys.
Thank you, Mr. Arnoco. Let's get down to the facts pertaining to this current petition of reinstatement and the previous case of disbarment of petitioner Rolando Torres. Ms. Cabañog and Mr. De La Cruz, you may proceed.
So these are the facts of the petition for the reinstatement of Torres as a member of the Philippine Bar. In Isidra Ting Dumali versus Attorney Rolando S. Torres, respondent Rolando Torres was disbarred for using his profession to deprive complainant of what was lawfully due them, even if it involved the commission of an illegal, unlawful, or immoral act. This involves the extrajudicial settlement of lots number 1586, 1603, and 1605. He even presented false testimony, failed to advise against the forgery of complainant's signature, and grossly misrepresented himself in court for the purpose of profiting from such forgery. So these are clear violation of Canons 1 and 10 of the Code of Professional Responsibility, which provides that a lawyer shall uphold the Constitution, obey the laws of the land, and promote respect for law and for legal processes. Canon 10 also provides that the lawyer owes candor, fairness, good faith to the court.
The court found Attorney Rolando Torres guilty of gross misconduct and violation of the lawyer's oath, as well as Canons 1 and 10 of the Code of Professional Responsibility, thereby rendering him unworthy to continue his membership on legal profession. He is thus ordered disbarred from the practice of law, and his name is ordered stricken off of the role of attorney, effective immediately. Torres twice moved for consideration, but were denied, and no further pleadings will be entertained. Torres filed an ex parte motion to lift disbarment dated January 26, 2006. He even wrote letters to former Chief Justice Artemio Panganiban and former Associate Justice Dante Tinga. Torres continued to file numerous submissions to reinstate him, but all of which were denied by court. More than 10 years from his disbarment, Torres filed a petition dated June 11, 2015, seeking judicial clemency and reinstatement. The court denied the petition for failure of proving that he had reformed himself. He also failed to reconcile with her sister-in-law. He showed no remorse against the act he committed to her. Still, the court denies the petition.
So what is the issue of the case, Mr. Libera?
Respondent Rolando Torres should be granted judicial clemency by the court.
Thank you for that. Now we have general understanding of the facts presented. Let us see and understand how the court ruled upon this matter. Ms. Capricho, you may start.
So in this case, the Supreme Court denied the respondent's petition in seeking judicial clemency from the court to be reinstated in the role of attorneys. In arriving at this decision, the Supreme Court explained that the principle which should hold true for lawyers, being officers of the court, is that judicial clemency, as an act of mercy removing any disqualification, should be balanced with the preservation of public confidence in the courts. Thus, the court will grant it only if there is a showing that it is merited. Proof of reformation and a showing of potential promise are indispensable. The Supreme Court has to be objective in granting judicial clemency. Thus, in re letter of Judge Augustus Diaz, Metropolitan Trial Court of Quezon City, Branch 37, in appealing for judicial clemency, the courts laid down guidelines in resolving requests for judicial clemency.
So to give us the outline of the guidelines, Ms. Laquindanum.
The first guideline in resolving issues for judicial clemency is, there must be proof of remorse and reformation. These shall include but should not be limited to certificates or testimonials of the officers or chapters of the Integrated Bar of the Philippines, judges or judges associations, and prominent members of the community with proven integrity and probity. A subsequent finding of guilt in an administrative case for the same or similar misconduct will give rise to a strong presumption of non-reformation. Now, there were 4 testimonials that were provided by the respondent. First is from Reverend Nelson D. Ferranel, where he said before and after his disbarment, he has been assisting the poor and indigent litigants in our community. Another is from Attorney Chofilo Pogeda Jr. He said that as a former law practitioner, respondent is humble, simple, and respectful to fellow lawyers, court personnel, and the presiding judge. Another is from a retired prosecutor of Cavite, Attorney Manuel Medina. He said that during my years as a prosecutor, I always met him in the Regional Trial Court of Cavite, where I can say in all honesty and candor that he was an exemplary officer of the court, punctual, and always prepared in handling his court cases. Lastly, from Secretary Justice, he said that the respondent is a person of good moral character and a law-abiding citizen. Testimonials and endorsements do not prove whatsoever that Torres had already successfully reformed himself subsequent to his disbarment because, for example, his fraudulent act that he committed to his sister-in-law, where he was still no showing that Torres had reconciled or even attempted to reconcile with his sister-in-law so as to show remorse for his previous faults.
So Mr. Lintogonan, you may proceed.
The second of the guidelines in resolving requests for judicial clemency talks about sufficient time must have lapsed from the imposition of the penalty to ensure a period of reform. In the case, the Supreme Court has no exact definition of the sufficient time that must lapse to ensure a period of reform. In relation to the petition of Rolando Torres, while more than 10 years had already passed since his disbarment case on April 14, 2004, his present petition has failed to show substantial proof of his reformation in relation to the first guideline. Accordingly, proof of reformation and a showing of potential and promise are indispensable and must be complied with before the court could grant judicial clemency. A note also, judicial clemency as an act of removing any disqualification should be balanced with the preservation of public confidence in the courts.
Good day. For the third guideline, the age of the person asking for clemency must show that he still has productive years ahead of him that can be put to good use by giving him a chance to redeem himself. It appears that the petitioner is already 68 years old. Clearly, he is at the sunset of his life, affording him with the remote possibility of living productive years ahead of him if reinstated as member of the bar. The government stand to lose at the possibility of reinstating him with his age, as by practical common sense, a ripe age of 68 years old is likely devoid of the required physicality to withstand the rigors of the law profession. On the other hand, while the petitioner may be physically limited on account of his age as to perform his functions as member of the bar, he may still be likely to be mentally acute and sharp, like many typical lawyers. However, the scale of benefits and loss the government may derive from the petitioner's possible reinstatement tilts in favor against the government, as with his ripe old age, he may have less time to significantly redeem his lost honor.
As to the fourth guideline in granting judicial clemency, there must be a showing of promise such as intellectual aptitude, learning or legal acumen or contribution to legal scholarship and the development of the legal system or administrative and other relevant skills, as well as potential for public service. Unfortunately, the court explained that petitioner has failed to provide evidence which will demonstrate his potential for public service. As he was already 68 years old at the time, the court was seemingly not convinced that he still had productive years ahead of him that can be put to good use if ever given the chance to redeem himself. Thus, just like the third, the fourth guideline was not complied with.
Fifth, there must be relevant factors and circumstances that may justify clemency. The court denied the petition, holding that Torres had failed to provide substantial proof that he had reformed himself, especially considering the absence of showing that he had reconciled or attempted to reconcile with his sister-in-law, the original complainant in the disbarment case against him. Nor was it demonstrated that he was remorseful over the fraudulent acts he had committed against her.
Here's the decision. The court has to be objective. Torres failed to comply with the necessary guidelines for the grant of judicial clemency. To wrap everything, Torres did not present any evidence to the court that he had rendered free legal service to indigent. He did not present evidence to show that he had reconciled with his sister-in-law the root of his disbarment, and no other evidence was presented on his petition to demonstrate his potential for public service, that he, now being 60 years of age, still has productive years in order for him to redeem himself. Therefore, the court denies the petition of Torres seeking judicial clemency from the court to reinstate him in the role of attorneys.
Thank you to our viewers and listeners for taking the time to learn upon this matter. I hope that you are all well and your families are all safe. Till next time, Merry Christmas and a Happy New Year.